Introduce on behalf of the people.
Deborah Schloss on behalf of the defendant, Mr. Lilly, who is approaching.
Your name, sir?
Jonathan Lilly.
What are we doing?
So, Your Honor, my client had a no bond. He had a warrant for his arrest. We had him arraigned. You set no bond.
I did.
And Your Honor, I'm asking you to consider changing that. The reason you set a no bond is that he did not test for a number of days. And the reason for that, it was a complete misunderstanding on his part. And as soon as he spoke with me about it, he tried to correct the situation. He believed that once he was on the supervision of community corrections or pretrial services, that he did not have to test any further. He was
Excuse me? Say that again.
Right.
Basically, the whole situation is when I signed that blue form, nobody explained to me what the form meant. So I took an assumption of thinking that I didn't have to do that and I was going to get parole.
No.
Yeah.
So, July 9th, he tested positive for THC. July 10th, tested negative on the ETG and PBT. The 15th of July, he tested again and was positive. On the 17th of July, negative, tested, negative, tested. 23rd, negative. But all those points he takes test. Starting in August, he just doesn't test.
Right, and that's, Your Honor, because he misunderstood. It's in terms of the positive, but
What changed in August?
It was just the simple fact that I thought that form meant I did not have to come in. Yes, it was my fault. I should have asked.
What
more
form?
questions. It's a blue form that basically is stating, I thought they was going to give me a parole agent and it asked if I was going through any type of care, through any agency for the drug testing.
And Your Honor, for the record,
That makes no sense.
For the record, Your Honor, we had not discussed this. The minute that I learned that this was going on, I did contact Mr. Lilly. He really did believe that, despite the
That's why I turned myself in.
And Your Honor, I told him, I want you to come to court to the testing facility and test immediately. So he went the next morning.
Today on this case?
So, Your Honor, I am asking, and I just want to explain the THC also. He had smoked pot before he was arraigned, so it was still in his system. It's not any new usage, and the levels went down. I am asking that you.
But we don't know if the levels always went down because at some point he stopped testing. And I would know that his last test may have been masking because I have abnormal creatinine.
Your Honor, he will test going forward. He's had a very tough lesson of being not on his job for a whole week. He's in danger of losing his job until that you lost your job. All right. And until that point, he was doing everything the court ordered. I really do believe, as much as you doubt it, Your Honor, that he really did believe he did not have to test when he was coming in regularly and doing everything he was supposed to do. So I'm asking, Your Honor, that you release him and he'll be testing.
He has one like that?
Yes.
Why?
You said it last week.
Oh, okay.
Your Honor, he will be testing and he will not miss a single test and he will not have a positive test. And I am asking you, he's been in the jail for over a week and I'm asking you, Your Honor, to please reinstate bond. He will do everything. I know it sounds doubtful, but he really did believe he didn't have to. He didn't do this intentionally. When I called him, he was shocked that he was still supposed to do this. So he legitimately did think he didn't have to.
I'm still trying to figure out what made him stop.
Your Honor, it was simply that misunderstanding of the form. It wasn't because I felt like I couldn't do it or that, you know what I'm saying, the test that went wrong. I simply was doing everything to a T, Your Honor.
And
What-
Your Honor, when I told him you have to immediately go in and test, he did. And they were just going to test him and let him go. He himself told them, I have a warrant for my arrest. He was very open and honest with them. He could have ended up coming in here that day and had this hearing. Instead, he was honest. They arrested him. He couldn't come in that day. It was too late.
If I reinstate his testing, will you stop?
Yes.
Anything from the people?
Your Honor, the people would like to be heard. When the defendant was arraigned, we actually asked for $150,000 surety bond. He was granted a PR bond,
When was this? The initial
the
arraignment?
initial arraignment. He was
Okay.
given a PR bond with testing, frankly, a gift. Obviously, he was unable to comply with that. But $150,000 was the request of our office. And the reason was this involved the defendant traveling under the influence of marijuana in excess of 100 miles an hour, broadsiding an innocent motorist and in the state of explaining and killing that individual. So the defendant's claim that he's struggling with work is a far cry from the woman who was minding her business, driving and was killed. I think that $150,000 surety bond is a much more appropriate bond in this case, given the facts and the charges, than a PR bond with testing, which the defendant wasn't even able to comply with.
Your Honor, he showed up to every court date. He did everything he was supposed to do until this misunderstanding. He will do everything. He had no criminal record, has no criminal record to date. We dispute.
You're saying he turned himself in?
Yes, sir.
Yes.
At the corrections, I also took. a
Well,
test.
no. So you didn't actually show up at the jail turning yourself in. You went to community corrections to resume your testing that you just unilaterally stopped.
Yes, sir. I said on the whim that she told me to take that as well.
And Your Honor, they were going to let him go and show up to court that afternoon, but he told them, I have a warrant. So they arrested him. So he was being open and honest. It's not like he was trying to abscond. Right after I told them about this.
I'm going to continue as bonded, no bond. I mean, I don't, unless you show me something else regarding that form, regarding that as to why he stopped, because he just stopped. And there's no reason. And in particular, given the nature of the case.
Your Honor, he had a good job. He was working. He would like to resume that.
What do you want me to do with the case?
Well, I would like to set it for another hearing, but I would hope that you would reconsider the no bond.
Yeah.
Can we have it, then can we set another court date, Your Honor?
Yes. But the fifth, well, actually, he's already set for the,
Okay, thank you, Your Honor.
Kenneth Overwater, Assistant Public Defender, appearing on behalf of Mr. Morris. Stands to my right. Your Honor, thank you for passing the matter. Mr. Morris, please state your name for the record.
Brandon Montez Morris.
he's gonna wear full pants next time.
Yes, I will, sir.
Thank you.
You want me to put the whole?
I need them to the floor at
I
least,
got
or at least to the top
I
of the
got
shoes.
you.
Thank you. All
How
right.
you want them? You want khakis or you want jeans? How you want me to do?
I
got you.
I just need you to have pants on.
Okay,
not sure.
Like whole pants. Got you, but.
Yeah, not like the half ones that you have.
Yes,
Some wind
sir.
pants, maybe.
Thank you.
Got you.
All right.
All right.
Yeah, I'd ask to set the matter for preliminary examination.
So this may not be my problem. All discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available on the 10th.
We'll do our best.
For date kind of longer than.
Preliminary examination will be set September 10th, 2024, 9 a.m. before Judge Burke. This is before Judge Burke in person. So that'll be good.
So you want to wear,
Trying to continue, so go ahead, wear shirts there. Let's see what happens.
be a different judge, but you'll
It'll
want
be
to
a
wear
different
pants.
judge, but I think you better
I
have on
should better have some pants on for him.
Oh, I think you might want to.
Maybe,
That's
Okay.
your business.
maybe a
All
collar
right,
shirt.
take care.
Yes, sir. Have a blessed day.
You do the same.
Thank you, Judge.
Thank you.
You're welcome.
I'm already in trouble. I'm in trouble now.